Well, hello. Is anybody there? I show that we've got four viewers on right now. We had 15 scheduled, so we'll wait just a few minutes. Um, just please make sure that you have pen and paper handy to take notes. There will be a couple of exercises that we're going to do on this, and as we move forward, this should be really good. So please hold on for just a moment as we get everybody and just kind of let them trickle in here. Okay, everybody, so this is the first time that we've used this technology, so if you guys can hang on for just a couple of minutes, what we're going to do, we're trying to get Alexis on so everybody can hear her as well. So if you guys will hang out, I apologize for the technical difficulties, but we'll be right back. Give it just a minute.
So you should be able Hi, can everybody hear me? Thank you, David. First, want to thank you for setting this up today, and thank you, everybody, for attending. I hope that you learned some valuable information about your brand and how to market it and how to protect it. So, not only is getting your name out there incredibly important, but trademark protection is a valuable asset for your business. Trademarks are a central element in the marketing and branding strategy of any company because they allow the company to differentiate itself and its products from those of the competition. So what is a trademark? A trademark is any mark that identifies particular goods or services and is used in the stream of commerce. So what is a trademark? Trademark is any mark that identifies particular goods or services and is used in the stream of commerce. There are 3 levels of protection for a mark: common law, state trademark, and federal trademark. The moment that you create a mark and start to use it in commerce, you have a protectable trademark. That's under common law. So without registering it, you still have several protections. If you are the first person to use a mark in a territory, you have dominant rights to that mark within the types of goods or services. So in the picture we have here, for example, if Acme decides to start selling anything in Washington, specifically hammers in Washington, Acme then gets the primary usage within Washington, even without registration. State trademark, though. State trademark is designed for companies that are beginning, that are small, that are pretty sure they're not going to want to move outside of the particular state, for example, Washington. It's a lot less expensive and it's a lot easier and quicker to file a state trademark. If you're a small company that doesn't have plans to expand beyond a region, a state trademark makes sense. Federal trademark, however, is the most common form of protection because it does grant the widest grant of protection to your mark possible. And any company that has any plans to expand outside of a particular state, which most of us do, prefer federal trademark. I mean, there are some reasons to stay within a state. I mean, for example, law firms. A lot of law firms like mine, for example, will only be licensed in 1 or 2 states. You can register your trademark in those particular states and then never have plans to expand. Other state licensed entities may want to just get a state trademark. But other than that, federal tends to be the safest route. It's a little bit more expensive, and it takes a lot longer, and there's a lot of paperwork involved, but it's definitely worth it. So what are the benefits of this federal trademark registration? So the most commonly stated benefit of trademark registration is nationwide priority. So in order to qualify, let me just back up for a second. In order to qualify for all of these additional benefits you see here, you have to have your mark on the primary register. So there's the principal and then there's a supplemental. If you're on the principal register, you get all of these benefits. We don't really have time today to talk about the supplemental register, but at some point we'll have another webinar and we'll discuss it at that point. You do get some limited rights with the supplemental register. So to qualify for registration on the principal register, your mark must be in use, it must be distinctive, and it must not be confusingly similar to another mark. We'll get into all of these in a little bit. Back to nationwide priority. Again, it's often cited as the most important benefit of registration, and especially for growth potential companies, which is where you all are now. Under common law, you have to use the mark in the particular territory where you seek protection, like we were talking about earlier. So if you're using your mark in Washington and someone in New York is utilizing the same or confusingly similar mark, you will each get your sort of piecemeal rights. You'll get the rights in Washington, they'll get the rights in New York. However, if you register on the federal trademark registrar, then you have priority throughout the entire nation. So somebody else in New York, for example, utilizing your mark would be infringing your mark. Once you register and you get that nationwide priority, any company that uses your similar mark after your date of registration would be considered infringement. However, it's important to note, though, that if that, for example, New York company starts using your mark before you registered your mark, then they still get their piecemeal area priority. For example, in this case from 1996, Baron Philippe de Rothschild versus Paramount Distillers. Paramount Distillers was obviously made spirits and registered the federal trademark, but unfortunately registered it just after Baron Philippe de Rothschild was utilizing it in a small area. Baron Philippe de Rothschild was able to take Paramount Distillers to court for infringement, and the court stated that yes, Paramount Distillers does have nationwide priority, but within that circumscribed geographic area where the prior use was already established, that prior use gets to continue such use without infringement. So the takeaway from that is failure to register in a timely manner before somebody else that you may not be aware of or in some distant area utilizes your mark or a similar mark, you may end up limiting the protections and priority that federal trademark provides to you. So let's go back. Not only is nationwide priority one of the main benefits, but also incontestability. After 5 years of continuously using your registered mark, you can apply for incontestability status. If your incontestability status is granted, no one can argue that your mark is either confusingly similar to another mark or that it lacks secondary meaning. We'll get into what secondary meaning is in a little bit. However, incontestability doesn't mean that your mark is bulletproof. It can still be questioned on several different issues such as genericism and registration abandonment and things like that, but that's beyond today's scope. You also get automatic right to sue in federal court if you register. Typically, to sue in federal court, you have to prove diversity jurisdiction and an amount in controversy over $75,000. It's not particularly easy to prove either of those things. So, but if you have your federal registration, you get an automatic in. You don't have to prove any of these things. However, even if you don't register, you could still pass those tests and file suit in federal court. And in some very limited situations, you may be able to file suit in state court also. One of the biggest ones is the statutory damages. You have a right to collect triple damages for willful infringement if you have filed it with the federal registrar. You also get evidentiary advantages in court. You get a presumption of validity, ownership, and use in commerce. These are very difficult, timely, and expensive to prove, but as long as you've registered, those are a go and given already. Then the defendant will have the burden of proof to rebut all those presumptions, putting the onus on them, the time, the effort, the expense. You also get a little bit of benefit and some tools to prevent cyber squatters. This is a webinar on its own talking about it, but there are tools that you can utilize once you register to prevent other companies from using your name to create a domain name for themselves. If you're looking to expand federal or internationally, register as soon as possible. If you think there's any potential that you will at some point expand, you definitely want to get your domestic registration because that domestic registration gives you priority in foreign countries. Those, especially, I mean, only if they have a treaty with the U.S., but most major companies do, or countries do, so that's really not a major issue. And pirates who will know that you're intending to expand will register marks in foreign countries when they know about your expansion and then charge you hefty licensing fees. So you definitely want to avoid that by just registering early on here. And then, of course, one of the most cited benefits is using the R in the circle is a great way to deter others from using your work, which will probably save you from ever having to sue in federal court. That's the benefit, is to protect your assets and save money. So now that we know the benefits that are afforded for federal or trademark protection, let's talk about what marks are registrable, because not all marks are. So marks range along a continuum from highly distinctive to generic. The more distinctive the mark, the more likely you are going to be able to register it. Some marks on their own they're unquestionably distinctive. The USPTO considers marks that are either fanciful and arbitrary as highly distinctive. Fanciful marks are made up of imaginary words, something that has no real purpose in society. For example, the well-known pharmaceutical company Pfizer, it's a made-up word. So that's a fanciful mark. It automatically passes all the tests. It can be registered. Arbitrary marks are words that are well-known, but they don't naturally coincide with the goods or services. For example, the word unicorn, if it was a brand name for boats or boating accessories, or, as we all know, Apple for computers. Next, we have suggestive marks. Suggestive marks, again, are those that are real words, but when they're applied to the goods or services, they require certain imagination or thought or perception to reach a conclusion as to the nature of those goods or services. So, for example, Roomba, for a room cleaning robot, it gives you some suggestion about maybe what it entails, but it's not nail on the head kind of thing. You have to kind of guess at it a little bit. That's a suggestive mark. Fanciful, arbitrary, and suggestive marks are all registrable on the principal registrar, which means you get all the protections afforded that we discussed earlier. Now, what marks aren't registrable? So, descriptive marks that are just merely descriptive will be refused registration on the principal registrar. A descriptive mark is something that it describes a quality, a characteristic, or an ingredient of a good or service. For example, I guess you could say clear for a bottle of water, right? And an important element of that water is that it's clear water. So that would be descriptive, and then it would not be registrable unless you can determine that the descriptive mark acquired distinctiveness, and as we know, distinctive marks are registrable. So it acquires distinctiveness through what's called secondary meaning. Secondary meaning is usually something that pretty famous marks will acquire. So, for example, the well-known holiday chain or hotel chain Holiday Inn has acquired secondary meaning. This usually requires a showing that through receipts, through just everything showing how well known the brand is, that your average person, when they see or hear that word, they associate it with the good or service acquired. So they have to have, that has to be their first thought, and then that is secondary meaning. Generic terms, generic marks, unfortunately, are not in any way registrable. And it's actually very difficult for a mark that has any creativity whatsoever in it to be generic. So the definition of a generic term is something where the word is the genus that the public uses for that type of product or good. In the example here, this is actually a real example from, I think, the 70s. Bundt, B-U-N-D-T, for a line of ringed cake mixes. A Bundt cake, that's typically how we refer to a ringed cake. So, Tissues Inc. or something like that for facial tissue, something like that. Those are generic terms. They're not registrable. Now that we know not only what benefits are afforded to registration, and also what type of mark you have to have in order to register it and get those protections, there are so many steps afterwards that you want to think about when you're focusing on your marketing campaigns. All of your marketing campaigns, in the back of your mind when you're doing them, you want to focus a little bit on brand protection and brand maintenance, because all the effort that you put into coming up with a unique mark and protecting it through registration could be fruitless if either trademark dilution or trademark disparagement happens to you. So trademark dilution is basically when another company utilizes your mark or a similar mark to the extent where it becomes genericized. Basically, it becomes what people would use for the genus of the word. So for example, Kleenex. Kleenex works very, very hard to make sure that their term does not become genericized. Kleenex is a brand name for facial tissue. Kleenex in and of itself is not the item facial tissue, but you hear everybody say, oh, just grab a Kleenex. This is something that you really want to be careful of as you grow. As you grow, people may want to use your term for the genus. For example, the Starbucks Frappuccino. Now, every time anybody has an iced coffee drink, they're like, oh, it's a Frappuccino. But it's not. It is a blended coffee drink. And so Frappuccino is a brand name for a type of blended coffee drink. And Band-Aid is a brand for adhesive bandages. But everyone's always, always says, oh, do you have a Band-Aid? So these are things you want to make sure don't happen to you. So you want to make sure when you're creating your marketing campaigns that you use the term brand or type of, right? So we have, for example, Coach is a brand of luxury goods, something like that. Trademark disparagement is something that could easily happen to you even before you start growing really big and growing both domestically and internationally. You want to actively monitor and defend your brand from potential infringers, because potential infringers who are utilizing your mark or a very similar mark, a confusingly similar mark, on a very similar product could have an inferior product. That, if people start to associate that inferior product with your brand, it's called trademark disparagement. And your brand loses goodwill that you've worked so hard to develop because of an infringer. This is where brand maintenance is really terribly important to monitor and check constantly to see who may be utilizing your mark or a very similar mark to make sure that your goodwill stays with your product. And that is our short presentation on trademark and the importance it has to brands and brand management. Thank you very much for your time. And again, David, thank you so much for setting this up.
Awesome, Alexis. Thank you very much. All right, so what we're going to do now is we are going to take some questions and answers. Let me get to that spot real quick. So in the comments area, if you could please post any questions you have about branding, about just anything about branding, about protecting your brand, whatever that might look like, and we'll answer those questions. Awesome, Alexis. Thank you very much. All right, so what we're going to do now is we are going to take some questions and answers. Let me get to that spot real quick. So in the comments area, if you could please post any questions you have about branding, about just anything about branding, about protecting your brand, whatever that might look like, and we'll answer those questions. All right, so what we're going to do now is we are going to take some questions and answers. Let me get to that spot real quick. So in the comments area, if you could please post any questions you have about branding, about just anything about branding, about protecting your brand, whatever that might look like, and we'll answer those questions.
going to do now is going to give some questions and answers. Let me get to that spot. Okay. So in the comments area, if you could please post any questions you have.
All right, so the first question is from Blair. Now, I've got a lot of background. Alexis, real quick, this is from Blair, so I'll give this over to you. What are the steps necessary to register a trademark?
Okay, so I'm going to turn the volume down because I'm getting really bad feedback, but I should still be able to answer it, but I won't be able to hear anything, so there will be a delay. All right, so the steps necessary to register a trademark. First thing you want to do is called vetting, and we talked about that a little bit in the presentation, because what you want to do is make sure you have a registrable mark when you're vetting the mark. So you want to go to the USPTO website and check their Gazette. Their Gazette has a list, and this is an intensively, this is a long list of all the marks that are currently registered. Make sure that the actual words you want to use are not there, and that any imagery you want to use is not on there, especially linked together. And this is where either hiring an attorney, or you don't even have to hire an attorney. You could hire. They have trademark services that you can utilize also that are a little bit less expensive than a trademark attorney, but they'll help to determine, in combination, the image you want to use, the words you want to use, the stylization, whether or not that those are vetted, whether or not they're not only not used by somebody else, but they're also just distinctive. So once you've vetted, then you go to the USPTO website, and the actual registration process is not terribly difficult. You'll have to supply a specimen of your mark, and then you also have to supply a specimen of it used in commerce. So if you have a good, for example, bags, Blair, right? So you make beautiful women's purses. You will want to take a picture of your mark on the purses, and you'll supply that to the USPTO. The prices to actually register range between $275 and $350, depending upon the type of registration you want to utilize. And so it's not terribly expensive to do it, and it's definitely worth it. And so once you do that, there's about a three-month delay, sometimes more. And if there are any problems, then they'll let you know, and you have an opportunity to fix it. And if they deny your application, you can always appeal. But those are basically the steps. You want to vet your image. You want to get copies of your image, copies of it used in commerce, and supply all the information to the USPTO on their application form, and pay the fee. And that's it.
Great.
Depending upon the type of registration you want to utilize.
All right, so what other questions are there out there? Thank you, Blair. I hope that answered your question. All right, so while we're waiting for some questions, I do want to tell about something that Alexis and I have worked out. Well, actually, it's mostly me, but what I want to tell you about is today, for those that are on the call, we're offering a very special, we're offering a special. I would like to talk about your brand with you. I want to set up a meeting with you to discuss what is your brand, what are you wanting to become, what is the identity versus the image of your brand. Now, usually for a 1-hour consult, just independent, you're looking at $250 an hour. However, for everybody on the call today, if you'd like to look at your brand, I am offering that consult for $97 today. So if you are interested in doing that, please shoot me an email. That email is dmitchell@boommybusiness.com, and we'll start scheduling that you for that consult, that $97 consult. And Alexis is also going to, for everybody on the call, do a free 30-minute consult with you as well to discuss what it will take to trademark and set up your registration. What does that look like, and what steps do you need to take specifically for you, because that's going to be very, very different. We're actually well ahead of schedule, so rather than it taking an hour and a half, it's looking like it's taking about an hour. Are there any other questions from anybody watching the webinar today? Alexis, do you have anything additional that you'd like to add?
You know, just like you said, David, it's totally up to the mark. Every mark is different, and the way it's utilized in commerce is always so different. So this really is an individualized assessment that everyone needs to do with their own marks. And just when they're branding and they're marketing, making sure that they're utilizing the concepts that you discussed while also utilizing protective mechanisms at the same time, so that not only can they expand their brand, but make sure they don't end up in court regarding it.
Okay. Yeah. You work so hard to develop a relationship, right? You work so very hard to develop a reputation for yourself, and all it takes is for one person to wants to impose on that, whether it's to do you damage or to try to lean on your own reputation, that things can go south. I mean, how many times have you walked into a store or seen a street vendor and picked up a false Coach purse, right? People want to lean on that, and that's stolen sales from Coach. Every time one of those knockoffs is sold, that's a stolen sale from Coach. Somebody that's trying to pretend to be Coach. And so protecting that reputation of quality and of style is critically important. It doesn't look like we're getting any other questions. Again, if you'd like to set up those appointments with me and Alexis, shoot us an email. Shoot me an email and we'll get that all set up. Again, that consult with me, that 1 hour branding consult, is going to be $97 to sit down and go through all the pieces of your brand and what that looks like. And then we'll also set up an appointment with you and Alexis to talk about trademarking and just setting up your brand and protecting that brand. So with that, if we don't get any more questions in the next couple of minutes, we'll go ahead and shut it down. Any closing remarks that you have, Alexis?
Just thank you, David, for setting this up. I mean, I think that there were some really valuable pieces of information transferred today.
Good. Well, thank you, everyone, for being on the call. We apologize for the technical difficulties. I promise that as I do these more, this will get better. So hang with us, and we'll see you later.